Sims as vice chair for the Louisiana Alternative Advisory Board.
I am LeVar Little, a member of the board.
Oh, I'm Greg Bordelon, Lake Off Louisiana, board member.
Okay, Chris, board member.
Darlene Jacobs, board member, New Orleans, Louisiana.
Okay, the board is represented today by Anna Dow. So Ms. Dow, if there's no business before we get to the adjudicatory portion, feel free to call whichever case you'd like to call first.
Since the parties are here right now, we'll go forward with the Cecil Brown matter.
Okay, is Mr. Brown here?
Yes, ma'am.
Okay, let's see, why don't we put, would it work if they were over there for you?
I can move that podium.
Just need to make sure the court reporter can hear you. Okay?
It's on wheels, right?
Okay.
And you're
Put it where she
represented by
can
an
see it.
attorney?
Yeah, Eric LaFleur.
Eric LaFleur is here as attorney. Mr. LaFleur, if you want to come to the podium and if Mr. Brown, if you want to have a seat back there.
Sponsor.
Yeah, I need you to speak up because I'm limited on my mic.
All right, is this loud enough the way I need now? That'd be good.
Okay, we are going to proceed pursuant to the administrative procedure. The Louisiana Rules of Evidence are going to use the administrative proceeding. They will be lax. I'm going to let Ms. Dow make an opening statement, and Mr. LaFleur, if you want to, you can, and then we'll just proceed as normal. Ms. Dow will put on her case, and then your attorney will put on your case, and the board may ask any questions they'd like of any witnesses, and then we will hopefully come to a conclusion today. If the board decides not to and chooses to take it under advisement, that's their prerogative. Yes, sir.
My wife, for 46 years, is also my bookkeeper, clerk, and everything else, and remembers better than me. Can I have her next to me?
If she can be called as a witness or anything, we can have her up there at that time, but as far as your testimony, well, let's just see what you can remember.
Fine, thank you.
Ma'am, I would like to request the sequestration of the witnesses.
Okay. All right, if you all have any witnesses here, we're going to sequester them.
We had his wife home.
Well, if she's a witness, I think she has to be sequestered.
Okay.
That's fine. If you could step outside.
Ms. Dell, you have any witnesses here?
No, I do not.
Okay.
We don't have any witnesses.
We will come get you as soon as you're needed, and if you're not needed, we will come get you when we're done. Thanks so much. Okay, we have the witnesses sequestered. Ms. Dow, if you want to make an open statement, please do so now.
Certainly. This is a hearing brought against a licensed auctioneer, Cecil Brown. It's docket number 12-003. This is on a complaint filed by Lance Chipman, C-H-I-P-M-A-N. This complaint was filed with the board. Basically, Mr. Chipman's complaint was that he felt that Mr. Brown had taken some items on consignment, which he held, which he sold at a lesser amount than the agreed upon price. He also complained that he did not pay the money or account within the time period. Also that there was no written contract for the amount because the amounts were over $500. And also, there was a failure on the part of Mr. Brown to retain items, documents that are required by our regulations to be retained for at least 3 years, specifically anything having to do with consignor sheets or consignor contracts. It is our position that Mr. Brown has violated certain portions of this. Mr. Chipman is from Kashmir, Washington, in Washington State, so I do not believe he'll be present today. We do have his complaint as well as a settlement document presented to him, and I'm putting that on as my evidence.
Mr. LaFleur?
Yeah, and I'm Eric, on behalf of Cecil Brown. But we'll concede that there was a contract, and there's an email in the evidence presented by Ms. Dow where the co-signer acknowledges having sent the contract. Mr. Brown doesn't have the contract. Of all the contracts that he doesn't have, it happens to be one that's in dispute. We'll concede that. There's a series of contracts that have lost since they moved office, and this happens to be one of them. The issue is, what was the amount of the contract, and did they amend that contract? Our position is that they amended the contract and it was so in accordance with their agreement. However, we were not able to find any email exchange that shows how they deviated from the original contract. The other thing that I think he's disputing is the storage expenses, which I think initially were not calculated correctly. We went back and recalculated it, and I'm not sure if there's an agreement on what that amount is. It was $6,530. I guess my point is, if it was sold for what he alleges, that would be $18,000. That was actually sold for after the contract was amended orally, sold for $9,500. If we live by the contract that he says exists, which is at $18,000, you subtract the commission and the storage expenses, the cosigner would be shorted, I guess you could argue, $170 total. That doesn't mean we didn't violate the rules, and that's what we're here for. I do know that we have tendered to the cosigner the difference, I think $1,550, which is what was agreed upon, I think, after the waiver of the storage. We have there's a little bit of animosity between the two of them now, so we haven't been able to reach an agreement on that. Otherwise, obviously we wouldn't be here today. So that's the status. I think that's our position on the case. We are willing again to tender an amount equal to $3,000 just as a good faith gesture, just to make the cosigner at least somewhat content in how it was managed. But at the end of the day, if we look at those figures, I think it's only $170.
Ms. Dowd, why don't you proceed with putting on your evidence?
Thank you. I would first put into evidence the notice of hearing for today's date, showing this hearing was properly scheduled and also should be allowed to go forward as Board Exhibit A. We have a copy of the complaint filed by Mr. Chipman dated March 30, 2012, which basically states that for his loader he received a post-dated check for $1,550 with an invoice charging $6,450 for storage a day. He did provide a copy of that invoice and a copy with the envelope and a copy of the check, which we would put into evidence as Board Exhibit B.
Okay. And has Exhibit B around so you all can take a look at it?
Mr. Chipman, because of the distance, he was advised of the hearing today, chose not to appear and asked that his complaint be considered by the board. I would also add that he did not allege as part of his complaint the failure to be able to produce a copy of the contract. It is true that he says he signed a contract, but he did not ever have a copy of it, he said. He's requested one and one was not provided to him. When we requested it to attempt to resolve this matter, Mr. Brown advised me that they did not have a copy of the contract. As I stated earlier, the regulations require, as an auctioneer, you're required to keep these kind of records for at least 3 years in case there is an issue. As a result of the fact that he did not retain that contract for that period of time, it has inhibited the board as well as Mr. Brown from resolving this issue because we don't know what the real contract actually said. He has provided a sample contract, after you have it here, but I cannot tell you today that that is the contract that was signed by the parties in this case. There was an issue with regard to the invoice, and you will see that there's a large amount of storage fees. They were miscalculated. I think Mr. Brown conceded that he did not count, or he did not appear to calculate correctly. When he did correct it, it did result in Mr. Chipman only being paid $1,550 for a front-end loader that was sold at auction, for which he said that he had asked for more money. So, in any event, his position is he did not consent to the sale of that item for the amount sold. He did not consent to paying that much in the way of storage fees, and that he did not receive a copy of the contract, a written contract, which would have set forth whether or not there was a requirement for reserve or not. Without that information, Mr. Brown is at potential liability for failure to have that contract in hand to prove what the agreement actually was. And we would hold, therefore, any agreement he says is tested against him because it's his responsibility to be able to produce the contract.
Have some questions?
Let me see if Mr. LaFleur has questions.
Well, the only thing I would ask, I mean, we concede on the, I mean, I don't know if we offer a stipulation in administrative hearings, but we stipulate to the things that you've just heard us discuss. The only thing I would ask is that the contract that he did provide, maybe you could make that part of the record, because that's the contract that they would agree would have been the one that he had signed if they still had a copy of it. It doesn't have the amount, so it doesn't help them.
Mr. Brown says this is the contract. Obviously, Mr. Chipman does not, because he's not familiar with the contracts, he will not say, and it's not completed. So I don't know, if there would have been a reserve, it should have been listed on the contract. He provided me a blank contract. He also, the terms and conditions, he has highlighted those terms which he feels, or we have highlighted those terms which he feels is important with regard to this hearing. I have no problem if the board wishes to see this, to introduce this as Exhibit C.
As it is blank, I'm not alleging that those amounts are in there, just to say that the conditions are on the reverse side.
Yes.
And those are the conditions we violated.
Okay. We will accept that as Exhibit Board C.
Now, I do have Mr. Brown's original response to the notice of noncompliance. I don't know if you've seen this. This is just what he
Yeah,
provided
you
to
can
the
make
board.
that part of the record.
Okay, and we'll go ahead and introduce this as part of the record. This was what was provided to the board as response on April 18, 2000.
Okay. That will be Board D. I don't have any stickers, so I just write them. It's okay, I mean, I can just write on the corner unless you'd rather stickers. Okay, do you have any other questions, Mr. LaFleur?
No, that's it.
Okay.
I have Mr. Brown here to testify, and his wife, who's familiar with the records kept in the normal course and scope of business, to answer any of your questions.
Okay.
Why the contract's not here, that type.
Okay, if any board members have any questions for Ms. Down, you can ask them now, or if you'd rather wait until we hear from Mr. Lee.
I have two questions.
Okay.
Was a copy of the contract sent to the accusing party by email or by letter? I understand you have a copy of the contract. Do you have any type of letters that show that you actually mailed him a copy of the signed contract?
We don't have any email records from that period of time, but
Yeah.
I mean, do
Mr.
you know if it was
Chipman-
emailed?
Mr. Chipman
or
has
faxed?
provided- No.
I didn't handle that.
It was
But
not
I do
provided.
know that in a letter, Mr. Chipman wrote him. I'm sorry, go
You
ahead.
better go that way, she
Okay, I'm sorry.
I hate to interrupt you mid-sentence, but since you're testifying, let's have you sworn in.
Oh, sure.
Would you raise your right hand? Do you swear the testimony you'll give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. I'm sorry to interrupt you. Please continue.
Answering your question, I don't remember if it was an email or a letter or what, but I know he got one because in one of his letters, am I right?
He says he did not.
He said he never got one?
Do you have anything to show that you actually sent it to him?
No, I never met the guy. His people brought this equipment in. You don't have a letter that he writes and says that he did get the contract, but he don't know what he did with it? He may have it.
No, and I will concede this. Mr. Chipman says that he signed a contract.
Yeah, that's
Okay, fine, I'm
There was
sorry.
someone signed a contract, but they would not provide a copy.
That's-
That was my
He
question.
did
Oh,
get the
okay.
contract.
Did you have anything that can show that after the contract was signed and ratified, you actually gave him a copy of it? So that he
No, ma'am.
knew what his rights were and you knew what your rights were?
No, ma'am.
My second question
Sure.
is that when the equipment was sold for a lesser amount other than the first agreed amount, was an accounting made to Mr. Shipman, and if so, when? How long after that sale?
2 years?
2 years after the sale is when you
I'm
made it
guessing
accounting?
two-
Why so long?
Because I couldn't sell it. We kept putting it in one sale after the other.
Okay, well, no,
Can I answer that?
maybe you misunderstood my question. When you actually sold the equipment,
Uh-huh.
when the sale went through, how long after a period of time that sale went through, did you actually notify your client that you had sold his equipment for a certain amount?
I would say within a week.
And do you have
And I may be
anything,
wrong, it may be 10 days, maybe 2
and do you have anything in writing telling him that you sold the equipment and how much you sold it for?
No, this was all on the telephone.
So it was all oral.
Yes, ma'am.
Do you have any telephone bills that show that you actually
placed a long-distance call to him in the state of Washington.
No, he called me.
Oh, he called you. Does he have any? Huh?
It was something she's been taking.
But did the client get a copy of it? Yes, so when? That's a big issue, for me anyway. Okay. So your answer is you don't have a copy of
I'm
it?
sorry.
Your answer is you don't have a copy?
No, I don't have a copy
Were
of
there
the
two?
telephone bills. Is that your answer?
Yes.
No.
Were there 2 pieces of equipment or just
I
one?
think it was about 4.
4, okay, so,
We started with either 4 or 5, and I'm sorry, that's why I wanted her in here, but I believe it's either 4 or 5 pieces.
so
of
we're
equipment.
down to 1 for the dispute, the last one?
Yes, ma'am.
Did you ever send him a letter stating that it was, storage fees were gonna start accumulating as of this date, or to let him know?
All on the phone.
Nothing in writing?
I haven't met until just the other day, an auction before this last one.
Is that the way you usually do business, over the telephone with
A
someone?
lot
And
of
you don't
times
put
the
it in
people
writing?
out- well, a lot of times the people out of state, no, everything is on right, but is written, but a lot of times when they're out of state, hey, I'm faxing you this, or I'm mailing you this, or I'll have my girl do this, and they fax it and mail it back. We remodel the office, I don't know what I did with the contract.
And your wife is the one that would be responsible for keeping those records? or
No,
someone else?
I am, I'm
So you're
supposed to be
the-
boss,
okay.
it's my fault.
Okay.
Cecil,
Sure.
what are your models is, Lou?
She-
I
she-
know it's a case loaded, but.
Yeah, it's, I can get her to tell you, but I don't remember. It's been a long time, I'm sorry.
Have you had this piece of equipment for how long?
I think almost 3 years.
And
And
here you are.
yes, 2.5, 3 years now, in 10, 11, 12, probably 2 years. I'm bad on time.
Well, how?
And if I say something wrong, I don't remember.
If you don't know, how did you calculate the storage fees if you don't know?
Because we went
offhand?
back, she checked back in her, what do you call that machine?
The software where they keep track of the dates
Yeah.
of delivery, and she was able to calculate the dates.
They do all of that. I don't know how to turn the computer on and off, but so my son, who is also an auctioneer, and my wife and my daughter-in-law, it's a family-operated machine. She went back and she said, no, Pop, it was this. What I did, I made a mistake, and I started it the day after the sale, and I should have started the fee 10 days after the sale, the storage fee. Can I explain something?
Yeah.
Okay, he brought 4 or 5 pieces. I think 2 excavators, a front end loader, a truck, and a dumpster. I sold 1 excavator. I had a problem with him on the very first excavator he sold. I called him to tell him he was asking $60,000 and I got 51. So I called for him and the girl said he's had a stroke. But can I let you talk to the mechanic? I said, sure, this is his New Orleans office. I didn't have the Washington number. So he comes on the phone and the mechanic comes on the phone. He said, what did you get for it? I said, 51. He said, man, sell that thing quick. And so I said, fine. Later on, he fussed about me selling it for 51. In fact, the machine went to China. Is the reason I remember this one machine, Komatsu or something. We sold it over the internet. And I said, yes, sir, I sold it. Who said, who gave you that right? And I said, I don't know who the lady is, but she gave me a guy named Al in the office, and he told me. So he fussed a little bit, but he did accept the check. Later on, he called me after every sale and said, did you sell it? I can't sell your stuff, Lance. Come get it. I said, we're not even halfway close to a truck and a side dump. What about the front end loader? I said, I'm getting $6,000, $7,000 per auction. I said, we way off. I said, I think you want what, $18,000, $20,000 or something like that. He said, yeah. He said, how high did you get? I said, I think 7,500 at the last auction. And I said, I don't think, come pick up your stuff. I can't move it for you. You were dissatisfied with the first piece I sold, which I thought I got time for. Come pick your stuff up. He didn't come. He would call after the next auction. Not even running it through the auction no more. It looks bad on me. It's not good for my auction site to keep running the same piece. We would even move it around and put new batteries on one piece and get it running and stuff like that. After and I can't give you the date, not this last auction. I'm having them every 90 days at my place. A lot of auctions in between. After the last auction, the auction before the last one, wasn't even at the auction. A guy came up to me. He said, I need a front end loader. I'm on a job. I need it real bad. I said, you're not going to want to buy this. I said, transmission trouble. He's a good buyer, and I told him what I knew about the machine. When we move it around, I said, it's got to warm up a while before it moves. So then he says, if I'm talking too much, tell me to stop.
It's too late now.
I'm sorry. After the last auction, he called me again, and he said, what do you think? I said, I can't get it to 75. And then he lowered his whatever we had agreed on the telephone, although it was never wrote down, it was just stuff he would tell me. How high you didn't want to go? And he said, between 10 and 12. He tells me on the phone later, I said, no, between 12 and 15. I said, Lance, you're wrong, I remember very well. He said, because when the guy came in, he said, I'm not going to give it to you. But I'll tell you what, I needed better, I'll give you 9,500. And this is common, you guys auctioneers, you know what I'm talking about. Okay, fine, I got you 95 for it, Lance. So I screwed up because I didn't have it in writing, I'm sorry. But I do this a lot and I still do it. I know I'm not too good at keeping records and stuff, but the fact of the matter is just the truth. That's the bottom line.
I'm sorry, Cassie, go ahead.
Let me just ask this one more time. So when you were telling him, Lance, come pick up your stuff, did you say because your storage fees or running?
No,
So
ma'am.
you all never
No, ma'am.
discussed it,
No, ma'am.
storage fees?
I didn't. I really didn't. I wish I would have, but I didn't. I remember I didn't.
In his letter, he said he wanted to meet you in New Orleans. Did you ever offer to meet him in New Orleans?
No, I said, I'm not going to New Orleans. I said, but you could come meet me.
And he said you mailed him a post-dated check for $1,550? Why was it post-dated?
She can explain that better than me, but I'll try to.
Okay.
The check was mailed on time. We had an auction on the 24th of the third month, January, February, March, am I correct? I'm guessing, of March. And Jacob was mailing out checks. He signs the checks, mailing out checks for advertising, all kinds of stuff. And on all the checks he was signing, he was writing 3, whatever the check is, 3, 22, 10 or 11, whatever the month was, the year was. And he put that date down. I didn't. I guess I could have checked it, but,
Were y'all having financial difficulties for that period of time?
oh, no, ma'am.
Right now,
They were
he's-
all written, I'm sorry.
and he said that he asked for a copy of the signed sales agreement and you refused to provide it.
That's not true.
Do you have a copy of the signed sales agreement showing what it was
No.
sold for?
No, ma'am. Oh, yeah, I have. No, it was sold after the sale. The guy came and bought it. I offered him to show him the check. I said, Lance, I'll show you. It's a check for $9,500. He said, I don't want that. I want my machine back.
But do you have anything on the person that bought it? Did you do any kind of a sales slip or anything with them, or you just took a check?
Just took a check. It wasn't in the auction. There's a reason we didn't have no record of it.
And he
Came
said-
after the auction.
Okay, he said that you lost the titles to the Peterbilt truck.
Did not.
You still, you have
Did not. I
copies of the
said,
title?
I did not lose them. I said, Lance, I'll get them for you. He said, never mind, I'll get my own. At that day, he was mad and he left.
So did you have them?
I think I still have them.
You think you still have them?
Yep.
I mean, if, after you do an auction, even if you do it not at the auction site, are you telling us that you don't get a bill of sale?
I didn't. I know the guy knew his check to it. I
You
didn't
never
it.
get a bill of sale? Okay.
I got a copy of the check, but tell me.
No, I just want to
And
know if
even
you ever
wrote
get
the
them in
sheet
writing,
on
I
it that
mean.
they- Okay.
Because you know, you're required under the auctioneer's laws to keep very meticulous records of these things.
Yes, ma'am.
You are required to do it.
Right. This was not auction.
May I ask one question also to clarify? There, you'll see that on the invoice that there is attached also supposedly a repair charges for this particular item, that there was no actual invoice attached, is that correct?
That's correct.
Okay.
And I didn't charge him for that because I couldn't find the invoice.
Well, it's listed on the,
Statement.
on the statement.
Okay,
that
well
you
then I
did
told
charge.
him, I said, I can't find it, Lance. Don't pay for that.
Okay.
So you didn't charge him for that?
No.
Is
Can I
that,
see the statement?
I thought it was deducted.
It was.
all
If
the-
it was,
It was.
well, if it was deducted, I definitely told him, Lance, I can't find the invoice for that doggone thing. Just take it off.
Well, how can he take it off if it's deducted?
Ma'am?
How can he take it off?
Well, then he didn't want the second check. The other check that I offered him, how much was it?
I don't remember how much it was, but he offered him to take it off
I
just to
offered
try
him
to
to take it
resolve
off
the
or
issue.
something, I don't know what it was.
But at that point,
It was just no on my machine.
Okay. Mr. LaFleur, do you want to call any witnesses or?
I mean, I guess,
Would you like me to explain that check?
I mean, I think you gave us your explanation. I have no reason to believe that that is not what happened. The question for the board to decide is whether or not that was a procedure you should have followed as a licensed auctioneer.
Yes, ma'am.
And that is the issue.
yeah, I mean, I think the point about the checks is all the checks written on that day were dated that day, whether they should have been, you know.
Well,
But if you want the, I mean, do you have any other questions about the calculation of the days, I think we changed the day. I mean, they went back into the new software and fixed the calculation on the storage.
That's
day.
not the only issue in this case. That's not the
I'm
main
aware of
issue.
that. I know that's not the only issue.
There are more
Just-
serious issues in this case.
I'm aware of that. So I will have Ms. Brown testify if she can provide you with any more information on, to
I
help
think
you
we
in
need to
your
hear-
decision.
I think we need to hear it. I mean, we need to question.
You want to
somebody.
hear her?
Well,
Okay, well,
we
let's
got a
have-
question. Somebody handle money.
Yeah, well, I'm gonna ask her to come in, sure.
Okay.
You know, I think make a, see, we got somebody to do handle the money.
Mr. Brown, you can just have a seat, and we'll have your wife sit beside you, have
Yes,
Mr.
ma'am.
LaFleur ask her questions.
Oh,
What's her name?
Phoebe, or her name's, Dana.
Dana?
Dana.
Danielle? Danielle?
Yeah.
Here, come over.
You want her up
This
Um,
is Phoebe Brown. That's his wife.
Okay, Ms. Brown, Mr. LaFleur, do you want to ask questions? Well, I don't, it doesn't matter.
I'm gonna let the
You
board
said-
ask the question.
Okay.
It's an informal hearing. If you could explain, Phoebe, I guess the question was about.
My question is,
I need to have her
according to the
Hold on. This needs to slow down right now. First of all, she needs to be sworn in. First of all, we need to go through protocol and let the judge handle it. And we need to speak one at a time and not jumping over each other. This will not be an accurate record.
Okay, Ms. Brown, would you please raise your right hand? Do you swear the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Okay. I think the board members have a few questions for you, so whoever would like to start, please feel free to do so.
Are you the bookkeeper?
No.
Okay.
I've worked off and on with Brown's Auction Company, and right now I am pretty much working on a regular basis because our previous people that worked for us are no longer working for us. So I'm kind of helping the new lady that was hired. I have worked in the past, so I'm very familiar with, the auction company. I worked for 5 years and then hadn't worked for about 4 years, and then now kind of.
So were you working during this time?
Ma'am?
Were you working during this time?
Kind of part-time, helping out. Now, which time are you talking
I guess the
about?
question is, are you familiar with the records regarding this transaction? Can you answer those questions?
Yes, because had access to Auction Flex, which I was able to go back into and, look up some of the records that were unclear because this was so long ago, it was like 2 years ago. And there was, I had to, go back and look and see what I could pull up.
So did you do like the consignor settlement statements?
No, not at that time, I did not do that. But, can I tell you one thing about it? Okay. The person that did that no longer works for us, and I was unable to, talk to her, but there was some fees that were charged, so I did have to go back into Auction Flex and pull up the records of when the equipment was brought, how long they stayed, and then kind of, redo it. And I have to tell you, I did have to, I think I sent a letter. Did y'all have a letter that from the other, there was a letter that I had written, just kind of maybe explaining a few things about the charges.
Well, my question
Okay,
is,
what was the question?
well, I asked if you did it because we don't have a copy of this contract, but this is allegedly a standard contract where you say that your storage fees are $5 per day, and then on the settlement statement, you're charging $7.50 per day.
The person that did that, I think, was she did it in error. I don't know why she wrote the 7, but I did refigure it at 5, and it comes out to,
Do you have a statement to show that?
I do, I think, I don't know how she came up with her records, but from best I could figure, okay. And he was erroneous in some of the times that he said he brought some of the equipment. When I went back and looked into Auction Flex, okay, the front end loader that I think is in question, he said was brought at the same time as the Peterbilt and the trailer. It was not. It was brought like 3 or 4 months earlier than that, because it was logged clerk in our July auction. he said he brought it in November, which he did. He brought it in July. And it stayed on our board a year and a half. And I think at some point, he told, according to the, I did have to read the letter that he wrote. According to the letter, I had to look at it and see that he told us that he was gonna pick up the equipment in the winter, which is the winter of 2010. He didn't pick it up till the winter of 2011. So, you know, it stayed in our yard for a solid, 3 pieces of equipment stayed in our yard for over a year after he said he was gonna pick it up. So I calculated as best I could 10 days after the auction until it was removed from our auction. That was the front loader. The Peterbilt and the dump trailer were brought in, I calculated it 10 days after the auction until he said he picked it up on January 4th. And that's where these figures come up. And it should have been $6,530 at $5 a day. Which, you know, that's how I came up with that. But I did not originally do that.
Is there any, since the board members are reviewing this document, do you have any objection to entering this as defense today? Anna, do you have any objections to this?
No.
Okay, we will, can I have that? I
Sure,
can get you a
I have-
copy if you need a copy.
I had about 3 copies. I didn't know how many people would be here, but I did make.
Well, I just need one
One.
if you want to pass the other 2 around, but I
Okay.
need one.
You can get it now.
I have another question.
Okay, please.
Yeah.
You don't know where the signed sales agreement would be at this time? You don't know where the signed sales agreement would be?
No. No.
And do you know why a post-dated check for $1,550 was given?
That, I had, my son actually is the one that wrote the check. He writes all the checks in our company. Okay. When the person that wrote up the invoice asked him to write out the check, and so I asked Jacob about, you know, why would that check have been there? He had absolutely no idea. And I'll tell you, we kind of came to the conclusion that this was written in January of 2012. We had our big quarterly auction in March of that year. At that time, it would be the time Jacob does all of the advertising, all of the proxy bids. He creates the brochures, and that's all that would have been done at about that time. And the only thing we could think of was he could have been working on some stuff that he had been saying March so many times. He wrote there. There would have been no purpose whatsoever for him to have written that.
There would have been
Except that
a-
it was, and he, as
There
far
have been a
as I
series
know,
of checks written all at that same time for the March auction, to pay March auction bills.
No,
And this was inserted in
actually,
there,
it
that's
wasn't.
right.
That's not my question,
No, it
Councilman.
was-
My question is, at the time that they wrote that $1,550 check for the consumer, did they have enough cash in the bank at that moment to cover that check?
Oh, yeah, definitely.
There's no question
No
about that.
question, no question. No question. It was a mistake when he did it. It should have been January 22nd, and he put 3/22.
Another question, Mr.
Okay,
I got a question.
sure.
Louisiana law requires you to pay consignors
Mhm.
with trust fund money. You
Mhm.
must have a trust account.
That's correct.
Now, is this a company check you wrote, or is this a draft on your
Escrow account.
escrow
A
account?
draft on escrow.
It's
That's the check?
It doesn't
It's a
say.
law to post date escrow checks.
Right.
Well,
I'm sorry, but, I mean, it is. You can't not write a post date check
Can I
on
see
a
a
trust
copy of that,
account.
Tessie? Can you?
It
can we
doesn't say
just-
Now, if he was
It doesn't
paying-
say escrow?
If he's paying bills out of your general account, I understand you post
Yeah.
date those.
Yeah.
When you write a check for a piece of consignment,
Uh-huh.
it must come from the trust account. And it must be that day it check's written.
This does
Well,
not say trust account.
no, it doesn't. It doesn't.
How many accounts do you have?
2. We have a escrow account and a general account. And it was my understanding that, now, I don't know about the consignments, but I had gone to, many years ago, a sales tax and which is supposed to be kept in escrow. And I asked the lady specifically, I said, can we transfer money when we pay something from escrow? Can we transfer it into our general account and pay it from a general account? She told me yes. This is at Louisiana.
You can pay the sales
Well,
tax.
well, but see, I
Not the
guess I
consignment.
assumed it could have been, you could have transferred. But the reason the post dated check, it was, I mean, as God is my witness, it was an accident. It was not meant to be post dated. It was meant to be January 26th, 2012. And he erroneously wrote 3/22. And we think because he had the march in his mind, he was working on that auction at the time, he just erroneously put 3/22 instead of 1/22. I mean, there would have been absolutely no reason to post date a check, you know.
So do y'all finish the bank statement?
I didn't bring them, anything, I didn't know that I needed to bring them, but, I mean, we have them.
Another question?
Yes, ma'am. Did he deposit that check, the guy in California, Washington? Has that check been
Did he cash
deposited?
it?
Not that, I don't think so, I don't think he did, because he told us he wasn't going to, you know. He was-
So he's never deposited?
I don't think so. I don't think he
Do
deposited.
your escrow checks say escrow account on it?
Yes, they do.
So clearly that's not from your
No,
escrow
that was,
account.
yeah, that was the general account.
Let me ask this, I'm trying to read between the lines
Sure.
here. Evidently, this check, since this was not sold across the auction block,
Mhm.
correct?
Mhm.
So I'm assuming that you thought you could pay out of your general account?
And that's probably
Is
because
that, was that, Cecil, is that what you thought?
I don't know, I didn't know the check, I don't know what check that it was, if it was the
So the
general.
fund.
it was at the general
Yeah, so I don't
account.
know what account it was wrote out of,
It
I
was
really
written,
don't.
it was written out of the general account.
Jacob wrote the check.
It was written out of the general account. It didn't not go through the auction, it was a private sale.
Well, if you recall.
But it was probably deposited
I see what you
into escrow. We always deposit checks like that into escrow.
Well,
And then, you know, when Jacob wrote the check, evidently he just, you know, wrote it off the general account.
you charged the guy sales tax that bought that machine for $9,500, you collected tax? Or
I didn't
you
do
just
it.
took a
I
check for
wasn't,
$9,500 worth?
I didn't charge any sales tax.
I
You
didn't.
just cut and run.
I should have,
I said you took the money, just cut and run.
yeah,
Get rid of
yeah, it was also glad to get rid of that thing.
But we do, I mean, it's not like we don't pay sales tax
Oh,
on
I
it, we do
understand,
pay
I'm
sales
just
tax,
trying
you
to
know,
find out.
yeah.
No, the
I know
check was
Cecil
wrote.
was a man of integrity, but I'm trying to get out what happened.
Yes.
And you're saying y'all had this equipment for over 2 years?
No, it was a year and a half.
It
And
was
he
almost
took,
2 years.
he was gonna pick it up.
So you had it 18 to 24 months.
Mhm.
And how many sales did you try to sell this in?
I'm a reckon about,
Well, if you don't mind, I would answer, because I did look it up in auction
Sure.
recs. I mean, I looked at all the
2 or 3
records that were
dollars.
clerked. The front end loader,
That's what I'm concerned, I don't care about this.
okay, the front end loader was clerked in 3 auctions. And, I mean, the high bid was,
Excuse me.
yeah, okay. Okay.
Okay, we just wait just a minute, the court reporter's machine has shut off. Just 1 minute.
Okay.
You understand? I'm terribly sorry. Well, I'm not plugged in, but I am plugged in. It's charged. One of those crazy little function things. I have a longer one. I have another one.
Give me enough.
Is that the model number, the lot
I
number?
don't know, I'd have to see, I'm not sure. Let me look at the 621. That's a model number on the vehicle, on the front end loader. It's a model
The
number.
621 case.
Mhm.
All right, this particular piece of equipment, how many sales was it clerked in?
3.
3?
And then he said he was gonna pick it up, and he didn't, you know, it stayed.
Okay. And then you finally somebody came by and said they'd give you $9,500.
That's, what I understand. I was not there, so, but that's what I understand.
That's all.
Do any other board members have any questions for Ms. Brown?
May I ask, just to clarify for the record,
Absolutely.
your calculation of the storage fees, you went back and recalculated based on the dates of the actual auctions, and you counted the appropriate 10 days?
Yeah, I did.
And that amount was 6530, is that correct?
Ms. Dowd, I'm sorry.
So how much are you saying, I know we want to take a check, but how much are you saying you're willing to pay him?
Well, we were willing to pay any amount, but he wasn't willing to accept, he wasn't willing to accept anything, so we kind of just stopped. But if I calculate, if he never did amend the contract, and we went with the $18,000 price, and you calculated the legitimate storage fees that have been correctly done, and a commission, that he would be owed $170. We had tendered $1,550, I think, based on the wrong numbers, and then offered as much as a total of $3,000. We were willing to offer up to $3,000, but I don't think he'll accept that either. I think it's just they're at a point where they can't, I guess he wants to have his hearing.
And I need to ask you a question. Have you talked to this man?
Yes,
You talked to him in person on the phone?
on the phone. He's never been here.
Is this man is sound or mind and memory? Is he sound?
He made sense. No, I would say that,
Or somebody mentioned the man had a stroke. That's
no,
why I asked.
he was irate, when I spoke with him, and emotional, but he he made sense. His, statements to me are exactly what are in his complaint letter, which I provided you a copy of. I saw no real issue with that.
That's all.
Okay, if there are no further questions, we'll take closing statements, and you all can put this under 5 minutes. Any further questions by any attorney or any board members?
I have nothing further.
Okay. Ms. Brown, you can have a seat. Okay. Ms. Dowd, as you make your statement.
With regard to this matter, you will see that there have been certain concessions today. We can all agree that Mr. Brown did not have a copy of the contract when called upon. It was within the 3-year period that's provided for in the regulations. Further, it is our position that there is some question as to whether we actually paid the consignment within 30 days or up to 60 days from receipt. I think the receipt was as of the day of the sale. I think their defense is that this did not happen at an auction and that the check actually never went through. So we don't know what day it actually was written, whether it was written on a post-date date or otherwise. But that would be a violation in theory of our section 3125B, that he did not pay timely. He did send an invoice which was incorrect. He did not rectify that until after the complaint was filed, and at this point he still has not, to my knowledge, attempted to pay the difference which should have been paid as a result of correcting the invoice. He cannot produce a written contract, so we do not know whether or not there actually was a contract which was written, which reflected either party's position on this because of that failure. There was also an issue with regard as to whether or not he provided an invoice for repairs that were or were not done. That was never provided to this office, to the board, or to Mr. Chipman, to our knowledge. As you pointed out also, there's a question as to whether he wrote this check on the actual escrow account is required to be kept. It is my belief that Brown's Auction does have an escrow account in place. It may have been improperly used, and the board can take that into consideration today. It's our position that these are serious violations and should be handled as such by the board.
Thank you.
Mr. LaFleur?
Yeah, again, on the issue of the check, it would be no different than if a lawyer wrote a check out of his operating account in lieu of his trust account. Something I have done very, very rarely, but I have done it in my practice. If Jacob Brown was writing a series of checks for the March auction, it makes complete sense that if she's given an invoice to pay, he includes it and he writes all the checks dated the same day. I agree it's improper use of the account. It's clearly a violation. The intent of the person doing it would have to, what I would hope would be considered by the board before you would take any adverse action against an auctioneer who's been in the business for 40 years and who's never had this happen before. On the issue of trying to deal reasonably with the cosigner, you can only deal reasonably with somebody with both sides or being fairly reasonable. He may have had all kinds of reasons to be irate and angry, but even in overtures to try to settle the matter, he wasn't willing. So we kind of came to an impasse where it didn't matter what happened, and so we had to come here no matter what was going to happen. Had we settled it, certainly we wouldn't be here, and I would have preferred not to be here. No offense to the members here. The fact that the contract forms is not on file, you're absolutely right, that's a violation. And a deviation from that contract that's not that's not in writing, at least by email, I would think, would have sufficed. But we have looked over all of the emails since they changed offices and they changed mail service. We can't find it. We were fortunate to have the auction software that I guess everybody's familiar with except me, but whatever it's called, where they're able to log in the dates of when products arrive or when equipment arrives, and so you have that contemporaneous record of when it came in. Not somebody's memory, you have a contemporaneous record that requires somebody to do something extra in furtherance of memorializing that. So I believe wholeheartedly that the record of the storage fees is very, very accurate. And so with that, yeah, it wasn't handled correctly. Should all auctioneers get in writing either by email or at least by text when somebody deviates from the contract? Absolutely. And it's an important lesson to learn. But I would hope that the board consider how it was handled, that we did as much as we could reasonably. We're still willing to do that, and hopefully he'll come around and be willing to offer what we think will be a reasonable settlement. Not $170, by the way, members. I just brought that to your attention to show you that the real net loss is only that amount, but we're willing to pay the man $3,000 and move on to the next auction. Thank you all for having us today. Appreciate it.
This time, is there a motion to?
Well, Judge, if magistrate, if there's some other record that you want, of course, we're not going to produce the most important one, but if there's a record out there that we could look for, we would give it, we could provide it to you if you give us an opportunity to. If that would help in making your decision.
Okay.
I think I'm ready to go into executive session.
Thank you.
Motion, can I have a second? All those in favor, please say aye.
Aye.
Any opposed, please say nay. Okay, we're going to go into executive session of what he's been charged with.
I so moved. Can I make that
For all
motion?
5 counts.
Yes, I do.
Okay, we have a motion to find Mr. Brown in violation of all 5 counts that he's been charged with. Is there a second? Is there any discussion on this motion?
There is a discussion. Mr. Brown, you can stand up if you will.
Yes, ma'am.
I mean, I think you've been very honest with the board in answering your questions, and I think that that's going to help you. But by the same token, it's our job to make sure that you follow the rules, which all auctioneers of Louisiana have to follow.
Yes, ma'am.
And for that reason, what we have is what maybe is a compromise verdict for you and also for the person who has made the complaint against you. Do you want me to give that?
Let's vote on finding him in violation, and then we'll take the second motion. All those in favor, please say aye.
Aye.
Any opposed, please say nay. That motion carries. And go ahead with your second motion.
It is the decision of the board that the claimant should receive $9,500 minus your 10% commission, and that you should be fined $1,000 for not keeping the proper records and for not writing checks out of your escrow account.
Yes,
And
ma'am.
that should be, the money should be paid within 30 days or offered to the litigant or claimant within 30 days. And if the $1,500 check is cashed by the complainant, then you would get a credit towards this amount. As I understand it, it's not been cashed.
Yes, ma'am.
Okay, that's the motion. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, please say nay.
No.
Two nays. Do you want a roll call vote? Mr. LaFleur?
That's not necessary.
All right, and that motion still carries. Is there any other business, Ms. Dow or Mr. LaFleur, with this case, with regard to this case?
I think this will, close the case as far as the board is concerned.
Okay, so you're gonna,
Maybe that way.
she says she thinks this takes care of the case as far as the board is concerned.
Okay, yeah, and it's reasonable. We appreciate y'all's time,
Thank
and
you, sir.
sorry for having to come before you.
Thank
Thank y'all very
you.
much.
Thank you.
Thank you.
We have, we can take, let's take a, is 5 minutes too short? Let's take a 5-minute break and then